You bring a lawsuit against your careless doctor, and now, after 2 long years, your case is finally approaching trial. As you are getting closer to trial, your attorney calls you up and says, hey, listen, the defense is trying to get your case thrown out. They're trying to get it dismissed. Did you know that you actually have to have a trial before you ever get to trial? You want to know what this is all about? Come join me on this walk through the neighborhood as I share with you exactly what this is all about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you brought a lawsuit claiming that your doctor was careless, causing you significant harm and injury. And now your doctor denies all of your allegations. You've spent 2 years prosecuting your case, and now your attorney has told the court that they are finished with the discovery part of your case, and now you are technically ready for trial. And now you're anticipating, you're hoping that you get to trial quickly. Before you ever get close to trial, your attorney calls you one day to tell you that the defense is trying to get your case thrown out. They've asked the judge to actually dismiss your case, and that's known as a motion for summary judgment. A motion is nothing more than a formal request, a written request to the court to take action. Summary judgment means that they want the court to give the defense a decision in their favor without ever going to trial. Now, how can they do that? Well, first of all, they can do that because once discovery is finished, and now you tell the court that you're ready for trial, the defense has one last shot at the apple before they ever get to trial. Their goal is to try and prevent you from ever getting to trial. If they can do everything possible to get your case dismissed without going to trial, they've won. They've won big. They don't have to spend money on experts. They don't have to prepare the case. They don't have to have a long drawn-out trial. They've won at that point. But how can they do that? They can do that by asking the judge to go ahead and dismiss the case, claiming that there are no questions of fact for a jury to decide. Now, what does that mean? What it means is that when your case goes to a trial, the jury, 6 members of the community in New York, they are the fact finders. They are there to decide who did what, who was right, who was wrong. The defense tells the judge, listen, judge, there are no questions of fact to be decided by a jury, so let's not even go there. In addition to the attorney's request, they have to support the request with expert evidence, with information from testimony that went on before the case ever reached that point, known as pretrial testimony, deposition testimony, as well as evidence from the medical records. So now they're going to accumulate all of that evidence, they're going to put it together in a coherent package, and then submit it to the court. So now you might be saying, wait a second, that makes no sense. The defense is doing everything possible to get the case dismissed so they don't have to go to trial, but now you're telling me that in order for the judge to make this decision, they actually have to go to trial? Yes, but there's a difference. When they go to trial now, during this request to dismiss your case, it's all done on paper. So the attorneys have to prepare as if they are going to trial. Attorneys have to get their experts to explain in exquisite detail on paper exactly why they are in support of the request to throw the case out or to show the court that there is a valid and meritorious case. So literally, the attorneys and their experts have to go ahead and prepare the case as if they are going to trial, and now the trial will be held on paper. And that means each side has to present evidence. Each side has to present their experts to explain to the court exactly why they believe that either the case should be dismissed and there are no questions of fact, or why there are valid points that the jury must consider and that there are issues of fact. Maybe the experts differ in their opinions. Maybe there's a problem with the medical record and now there are significant questions of fact that only a jury can decide to determine who is more likely right than wrong. If the judge determines that there are questions of fact that have to be decided, then he will deny the defense's request. If the judge determines that there are no significant questions of fact, then it's possible that he could say, okay, Mr. Injured Patient, you do not have a valid case and I'm dismissing your case. At which point you then have to decide whether or not to appeal. So why do I share this information with you? Nobody really talks about what happens as your case is proceeding to trial, and all of a sudden you get told, hey, by the way, the defense is trying to dismiss your case, but before you ever get to trial, you have to have a trial on paper. And you're like, what? What do you mean a trial on paper? Literally, it's like having a trial on paper. Getting all the witnesses lined up, getting all the evidence lined up, and now putting it together in a package so that the court understands it, so that the defense understands it, and each side has an opportunity to respond to the other's arguments. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I hope you have a wonderful day. Bye-bye.